Welcome, everyone. My name is Jessica Kiko. I use she, her pronouns. I'm the Director of Training at the Massachusetts Immigrant and Refugee Advocacy Coalition, or MIRA. And we're happy to have you here today so that we can all learn about what is in the PROTECT Act that was signed into law just yesterday by Governor Healy. I want to introduce our panelists and speakers for today, my colleagues, Gil Calderon and Amy Grunder. Gil is our Director of Advocacy and Amy's our Director of State Government Affairs, and they have both worked really hard on the PROTECT Act over the past year or so, and really hard on similar legislative initiatives and related work long before that. So with that, I'm going to go ahead and spotlight our panelists and then turn it over to you, Amy and Gil.
Hi, good afternoon, everyone. Thank you so much for taking the time to be here. I just wanted to quickly let you folks know about the Protecting Massachusetts Communities Coalition and campaign as to how we got to this point. As many of you know, when President Trump took office, along with the rest of his administration, we started. They put some goals together of what they wanted to accomplish. And, it was to deport 1 million people per year. And that, if you break that down, that's 3,000 people per day. And they were stripping the legal protections of, immigrants who have been told by the federal government to do everything the right way, and et cetera. And we're witnessing that right now with a lot of our TPS recipients from Haiti and from so many other countries. So how did we respond here at MIRA? Well, at MIRA, we ended up responding by launching the Protecting Massachusetts Communities campaign, also known as the PMC Coalition. This was chaired by Lenita Reason at the Brazilian Worker Center and chaired by our very own executive director, Liz Sweet from the MIRA Coalition, along with our labor partners at the SEIU unions, 509, 1199, 32BJ, and State Council. Of course, our Mass Teachers Union and our friends at the ACLU of Massachusetts and Jewish Alliance for Law and Social Action at JALSA. And I want you to know that this list is not exhaustive, right? There's many of you who have been advocating with us, including CPCS and so many other organizations who have attended our monthly calls and reached out to their elected officials. But the formation of this coalition really came around the idea of what we can control and what we cannot control. And we came up with 3 priorities or actions that the legislature could take this session to have an immediate effect on the lives of immigrants across the Commonwealth. And those 3 are banning any new future 287G agreements. So these are the agreements that turn local law enforcement agencies into extensions of ICE. We just simply did not want them doing their bidding. Number 2, we wanted to prohibit informal partnerships or operational assistance to ICE. This includes asking about immigration status. And lastly, funding immigrant legal assistance to give people a fighting chance to win their deportation or detention cases. While that's not present in this particular bill, that was a section that we focused a lot of our advocacy and attention on. But after nearly, a year of advocating, attended public hearings, and engaging the electorate to push their elected officials, the Black and Latino Caucus unveiled the PROTECT Act. As you know, this is a group, as the name suggests, Black and Latino legislators who are immigrants, children of immigrants, or represent immigrant-heavy districts. They did their homework, right? They consulted a wide range of community stakeholders, including us as part of the PMC coalition. The bill includes key provisions that the MIRA Coalition, along with so many community partners, had long advocated for under what was previously known as the Safe Communities Act for over a decade. And I know my colleague, Amy Grunder, will give you a quick overview of that timeline. But before I pass it on, I just want to mention one thing about this bill. This bill does not regulate ICE because federal law limits a state's ability to do so under the Supremacy Clause. Instead, it regulates how Massachusetts agencies and institutions interact with ICE while also creating state law remedies and oversight. And I wanted to make sure, and you'll learn a little bit more about that in this presentation. Next slide, please, and I'll hand it over to my colleague, Amy.
Well, greetings, everyone. It's great to be joined by all of you today. So as Gil was saying earlier, the PROTECT Act is really the culmination of 13 years of advocacy for immigrant protections in Massachusetts, beginning, as you can see here, with the Trust Act, which was first filed in 2013 to end the law enforcement practice of holding immigrants on immigration detainers for ICE to pick up, a practice that was ended by the Massachusetts Supreme Judicial Court in 2017. And that bill was filed for a couple of sessions, did not advance. And it's important to say that was a new idea in Massachusetts. States had just begun enacting laws like this because the federal government had begun commandeering the resources of state and local law enforcement earlier, I guess, beginning in about 2011. So the bill didn't advance then. And I should also mention that it really wasn't possible in those days for lobbyists or advocates to speak openly about undocumented immigrants. It was a different legislature and a different time. Instead, we referred to people with an insecure status or immigrants vulnerable to deportation. So this is where we were a little over 10 years ago. And then after Trump was elected in 2016, the Trust Act expanded to become the Safe Communities Act, and filed again by Senator Hillary, filed the original Trust Act, and with then Representative Matias. And this bill had additional protections, including 7G agreements on questioning about immigration status. It included limits on information compared with ICE and protections for immigrant detainees, core elements of the president considerably developed in the protected.
Amy, sorry to interrupt you, but for me, your audio is a little bit muffled. I'm wondering if you may have blocked your mic in any way.
How is it now?
It's better. Yeah.
Oh, it's better. I see what I was doing. Okay.
Thank you.
Clear enough? Okay. All right. And then after Trump was elected in 2016, that, of course, generated huge public interest in protecting immigrants from ICE. The Safe Communities Act was filed. Many of those elements, again, were the elements in the Protect Act, in the Safe Communities Act, were developed in the Protect Act. And then when in 2018, this isn't mentioned in the timeline, but in 2018, that first session, the Public Safety Committee sent the bill to study, and then we mounted a campaign for inclusion in the state budget and successfully leveraged the family separation crisis at the border to engage the public. And that passed in the Senate. That was the first time 3 provisions of the Safe Communities Act passed in the Senate. Some of you may remember this. It was the first time that either chamber had passed legislation designed explicitly to protect undocumented immigrants. So that was the first crack in the dam. And then that was followed by the pandemic, which was then leveraged by the spectacular advocacy by the Driving Families Forward Coalition to bring the Work and Family Mobility Act to the finish line. That was the first law in Massachusetts that was passed that explicitly benefited undocumented immigrants and ended a pipeline to deportation. That's really important to say as well. And then in quick succession, we saw the Tuition Equity Act also filed as a budget initiative by the Senate president. That law gave access to in-state tuition and state financial aid for Massachusetts high school completers. In other words, people who'd completed about 3 years of high school in Massachusetts, regardless of their immigration status. And then we had the Physician Pathway Act in 2024 with a pathway for internationally trained physicians to practicing medicine here in the state. And then after that, we got the budget initiative. While we didn't get the bill for the Immigrant Legal Defense Fund, we did get a budget line item for the MACI program, and the Massachusetts Access to Counsel Initiative, which has now been funded successively 2 years in a row, and which we expect to continue. And that funding is to defend immigrants who are at imminent risk of deportation, including folks who are in detention, immigration detention. And then finally, Trump's elected again, and we have and the issue of protecting immigrants is once again a hot button issue, lots of public support. And then, so we had the creation of the PMC Coalition, as Gil just suggested, then followed by the emergence of the first version, the original version of the Protect Act by the Black and Latino Legislative Caucus, which was then strengthened, I think, on the Senate side and negotiated into the final bill. So that's the timeline right there. And in case we didn't mention, I mention again that, please hold your questions till the end. We're happy to answer. But we can see here on the left-hand column, that was the budget campaign in 2018, the campaign for inclusion of Safe Communities Act provisions in the fiscal year 2019 budget. And you can see the upper left-hand corner was one demonstration where we invited 200 people to come and stand in front of the State House, and 2,000 people came inside. And here they all are inside the State House. And then on the right-hand side, you see this year's Immigrants Day at the State House with volunteers outside holding the signs. And then inside, you can see our table with our organizing team together with, I believe, Jessica, I see her as well, who is also on this webinar, and our volunteers. So here we are with the meat of the bill, and I'm inviting my colleague Gil to jump in here as well. So here, the first provision ends any new or expanded 287G agreements with ICE. And these are agreements that deputize or give ICE enforcement powers to state and local law enforcement. Not to be confused with the bed contracts at Plymouth, or what we call detention contracts. This new provision does allow the continuation of the single remaining 287G agreement in Massachusetts, which is the agreement between the Department of Corrections and ICE. The Department of Corrections runs our statewide prison system. But there also, if the governor chooses, if in order for the DOC to choose to expand or renew that agreement, they need the permission of the governor. Now, there is an exception in the text of the bill, which was added from the House bill, which says that a police department or sheriff can apply to the governor for a narrowly tailored 12-month, what they call a 287G agreement, limited solely to executing criminal warrants and summons issued by a court, not immigration enforcement. But we know that the 287G statute is designed for immigration enforcement, so it seems to it contradicts itself. So we don't expect this to have a real impact because, again, we're concerned here with limiting civil. All immigration enforcement is civil. When you come down, well, there is some criminal, but in terms of deportation, that is all civil. And of course, any federal reimbursement received under the DOC's existing 287G agreement with the DOC must be deposited into the Massachusetts General Fund. Gil, do you have anything to add here?
Say that, this piece here is quite important, right? For many years, we've been concerned about police and sheriffs becoming extensions of ICE through these contracts. And there's been numerous reports, even from 2008 during the Obama administration, where think about this as street level enforcement. There's many different types of 287G agreements, but the street level enforcement was one that, we were very concerned about because in states like Arizona and Virginia, that led to a lot of racial profiling, right? So if you speak a different language or you have a different skin tone, et cetera, folks were being pulled over, asked about their immigration status, and were being pulled over simply because they looked different from the population there. So I think this was incredibly important. And I think here in Massachusetts, many of you probably know this, but sheriffs are elected offices. And while we may have not had any 287G street level enforcement, many of these sheriffs in elected positions could come back on a type of agenda. So this, generally closes the door to that as well. So that's something I wanted to add there.
And this was, of course, a priority of the PMC Coalition, really concerned about especially police departments, which we haven't had recently, but we were very concerned about those. Do you know how many 287G agreements there are nationally now? Do we have that number?
Last time I checked was well over 2,000. And I think what's important to know, there was 135 of them in January of 2025, and now it's August 6th, and there's well over 2,000. Other states, like the state of Florida, has chosen to extend these 287G agreements to public universities and other places that we had not heard of before. So it's created a huge chilling effect. But I think what's important about this is to put up this firewall, right? To say that local law enforcement agencies should be focused on public safety, not enforcing federal civil immigration laws.
Thanks, Gil.
Next slide, please.
Okay, another thing, another provision that was introduced by the House, was in the House version of the bill that they voted, is protections for detained immigrants and inmates. So this provision applies not only to, this applies across all correctional facilities, including prisons, houses of correction, jails, etc. And in Massachusetts now, there is a standardized procedure upon intake. So upon intake, the facility, which is a Massachusetts facility, even in Plymouth, it's a Massachusetts facility. Remember, that's holding people in ICE, people who are in ICE federal detention, right? All of them have a responsibility to provide written notice in the detainee's primary language of their right to legal services, their right to decline interviews with ICE or other law enforcement. That was in the Safe Communities Act, the original. How to contact legal services and to inform them about grievance procedures and how to access those as well. And then in addition, they have to ensure detainee access to daily confidential telephone contact and video conferencing with their attorneys, and allow and ensure remote access to court hearings and proceedings. Next slide here. There's more. They also have to track the custody status of their detainees and provide it to the detainee's attorney or designated contact and notify them of any transfer to another facility. As you know, people have just been disappearing in facilities. Families have no idea whether they've been transferred, whether they're in our facility here in Massachusetts or not. They also have to provide a public phone number for callers to confirm custody and contact information for detainees. They have to provide transportation to court hearings and proceedings and document their compliance and promptly contact the attorney of record if there are any missed or rescheduled appointments. It makes them also accountable for providing meaningful language access for intake materials and for interactions with the facility's services or disciplinary proceedings.
I know that was a lot of information, but what I would like to add, to this particular topic is that this provision protects immigrant detainees held in ICE custody in Plymouth, as well as inmates in Massachusetts prisons, houses of corrections, and jails. However, this does not apply to the Burlington ICE facility, which is privately owned and operated exclusively by ICE, which Massachusetts law cannot regulate. However, that facility is subject to audits by the state auditor, which we'll talk a little bit more on later in the presentation. And the effective date of this is 90 days after signing, which is that little red bubble on the right bottom corner. Throughout these slides, you'll see the effective dates when each of these provisions go into effect. Next slide, please.
Okay, here is another. Now we're getting to the provisions that deal with informal collaboration with ICE. There are limits on information sharing with ICE. So the prohibition here, it prohibits police, sheriffs, and courts, and this applies both to employees and to officers of law enforcement and courts, etc., from sharing information, sharing non-public information, personal information, information about custody status, information about upcoming court appearances, and providing information about advance notice of release from custody. Because, of course, a lot of times when people disappear into ICE custody is when they have learned from ICE officers have learned from a sheriff of someone's upcoming court appearance. So they are snatched before they even get a chance to appear in court. The same thing at the end of release from custody. ICE is made aware of that release and is there to pick up the person when they're released. Now there is an exception here, and the exception is a big one. It allows any of these allows police, sheriffs, and courts to respond and share this information if there's been a written request from ICE about a specific individual received within the past 30 days. Now, this is concerning because this basically means that when law enforcement or courts receive a detainer request, or sheriffs receive a detainer request, that is a written request, and it refers to a specific individual, and they are allowed to provide that information. It also doesn't include, it's not a prohibition on old detainers. So what happens with a detainer request? So the detainer request is a request for detention, but it also includes a request for notification, right? Always. And so the concern is that when they get the request for notification, they'll be able to respond. If they actually get this written notification. So that's one question. The other issue is that it's for written detainer requests received within the prior 30 days, not they could be older than 30 days. It's just when the data received. So you can end up with old detainer requests, which follow a person through their legal proceedings. There's another exception here as well, which is that it allows these officials to give advance notice of a person's release from custody at the end of a sentence of incarceration for certain delineated crimes. They're delineated in the statute, and they include certain sex offenses, drug offenses, firearms offenses, and domestic abuse offenses. So those are the two big exceptions. I will say that on the other hand, what they end is the ability to respond to oral requests, which are becoming quite common now. And Gil can say a little bit more about that. Another thing that's in this provision, though, is that it does clearly state that that local municipalities, cities and towns can enact, and they should enact it doesn't say this, I'm saying, and they should enact stronger protections than what's in the law. In other words, this is a floor, not a ceiling. Gil, would you like to say more about the impact here?
Absolutely. I think this is an area significant in terms of this bill, because in the past there wasn't always clear statewide rules about what information could be shared with ICE, right? For example, this part of the law could, an ICE agent could call a law enforcement agency and say, okay, who do you have today? Et cetera, in order to grab that. So this prevents responding to what we like to call phishing expeditions, where ICE requests information about everyone who may be in their custody. And ICE must be seeking information about a specific individual. So this adds a few, barriers to prevent that. They have to know who they're looking for with all this information, and it puts up some roadblocks there. Yep, next slide. Yep, perfect.
Also, another form of informal collaboration are stops and questions about immigration status. So this provision prohibits police, sheriffs, and court officials and employees from questioning or maintaining information, recording and maintaining information about immigration status. So they're not keeping records about it either. There are a few exceptions here. One of them is for the investigation of crimes where immigration status is relevant to establish the crime, such as a human trafficking offense or of a state felony. Again, kind of a big exception there for state felonies for investigations, but it does have to be documented. So it can't just be because a police officer wants to stop someone and get information about someone's immigration status. It actually has to be documented. It has to it has to be relevant to an actual investigation of a crime that's been committed. And then also the exception for as required by federal or state law or treaty. For example, consular notification is by treaty. People have the right to get their the police will notify, or whoever's holding the person will notify consular officials that they have someone in custody if they wish to share that information, because consular officials can help. And also it's pertinent for firearms applications. That's state law. You have to have there are immigration status requirements to apply for a firearms license. That's it. Next slide. Unless you have...
Yeah, I just wanted to say this is a very important, piece here. Why does this matter? Well, for when immigrant communities are really afraid that every interaction with police could turn into an immigration inquiry, people become less likely to report crimes or cooperate with investigations or seek help. Many folks in Massachusetts live in mixed status households, and if something happened to a family member, right, they may not report that crime or, serve as a witness for fear of putting their family members they're putting their family in jeopardy because of that. And I heard someone say yesterday that you don't gather more criminals, you lose more witnesses. The crimes don't vanish, but the witnesses do. And I thought that really helped wrap that up very nicely. But ultimately, this section here will help build, trust between our immigrant communities and, public safety officers. In that way, we want to be able to have folks that when something happens to them, that they can report the crime or be a witness in it.
And just to jump in, sorry, to provide a little more clarity on consular notification. So that is in the 1963 Vienna Convention on Consular Relations, which is an international agreement that requires local authorities to inform detained foreign nationals without delay of their right to contact their embassy or consulate for help. So just clarifying that. Next slide. Okay, some other limits. Officers and employees of police, sheriffs, and courts cannot use or allow the use of state or local resources for civil immigration enforcement or participate in it. They cannot stop, arrest, search, investigate, or detain someone for civil immigration enforcement purposes. They can't hold someone based solely on an ICE detainer. Remember, that's actually a codification of that decision by the Supreme Judicial Court, the Lund decision. And they cannot transport someone into ICE custody without a judicial order. I think we're still a little unclear about whether transport is the same as transfer, because sheriffs, for example, sheriffs transport a lot of people in their custody to court. I'm not aware if they also transport people into ICE custody. I'm sure that happens. Again, the transference of custody is slightly different, and I'm not aware of the legal meaning there, but that's something we can find out and learn more about. And go ahead, Gil. If you want to add anything, also there's a 30 days for that, for the effective date here.
Nothing to add on this piece. I think you covered it well.
Great. Okay. Courthouse protections. These are a big one. Everyone is aware, I think, here that there've been over 600 arrests inside of courthouses or around courthouses over 2025. The new law would prohibit civil immigration arrests inside courthouses, but also on defined courthouse grounds, including plazas, steps, sidewalks, parking lots, lawns. It also includes garages that are connected by walkways, and those walkways to judicial property. So it's quite expansive, and we're really happy to see it. That was added as a technical amendment during negotiations, and that is also has an effective date of 90 days. And then we have sensitive locations protections. I want to precede this comment by saying that we've been focused mostly on protections against on limitations of law enforcement and court involvement in civil immigration enforcement. Not going too much into the weeds here, but what we with the rest of the provisions. But what we can say is these sensitive location protections are quite broad. They prohibit immigration, civil. Actually, what they prohibit is civil arrests, which of course includes civil immigration arrests without a judicial warrant, which is rare to have a judicial warrant for civil arrest, and also obviously without it prohibits civil immigration arrests in schools, childcare centers, and non-public areas of healthcare and group care facilities such as nursing homes and other congregate facilities. And it also requires adoption of policies and training on responding to civil immigration enforcement, and requires model policy development by the relevant administrative agencies. Anything to add? Worked quite a bit on this, Gil.
Well, I don't know that I have anything to add, but I'm sure many folks will have questions on how this is enforced, et cetera. I just want folks to know that, now that this has become law, it's there's going to be many different state agencies that will have to come up with the model policies and talk through, enforcement, et cetera. So we may not be able to answer some of those, questions right away, because that enforcement and model policies are being or will be developed. And I know, certain organizations already have their own plans, in case in case they ever interacted with ICE as part of their business or, facility, I should say. That's all I had to say about that.
And then there are guardianship protections for families. There is a provision that allows parents or guardians to pre-arrange guardianship for their children if their parents are detained or deported, so you don't end up with basically abandoned children. It's sad that we have to include that one. Yeah, go ahead. Next slide is fine. That one's self-explanatory. And then additional U&T visa protection. So these are U&T visas are visas that protect victims of crime by allowing, if they have cooperated with a prosecution or investigation of that crime, they have their protection against deportation from a U or T visa. They can apply for that protection. And it now at least, but it has to be a qualifying crime. So what the bill does is lists additional activities that can meet the definitions of qualifying crimes if accompanied by threats of deportation, intimidation, or retaliation. This is a really big problem, right? Particularly for immigrant workers and others. And it reduces the required response time from 90 to 45 days. In other words, in order to get this protection, they have to first apply to the certifying agency. Usually this is a law enforcement agency, but includes other agencies as well. And those agencies, there's oftentimes long delays. I don't have a lot of information about this because it's not my area. I don't know if you know a little more, Gil, about these visas.
Just as much as you do.
Yeah, I mean, Jess, if you want to jump on, you can say something about this.
Well, I know a lot about U&T visa, but I think you all covered kind of the relevant portions, right? In order to apply for the U visa in particular, an applicant first has to receive a signed certification form from a law enforcement agency. And so a number of years ago in Massachusetts, we passed a law that forced agencies to actually acknowledge the receipt of the requests to review and sign these certifications. And to respond in a 90-day period. And now that has been shortened to 45 days and even shorter for certain emergency requests, because we know, of course, that things can move quickly. Certifications are not required for the T visas, which are for victims of trafficking, but can also be helpful in those applications. So that's what this is meant to address.
Great. Thank you so much. And then many of you may have heard of an I-9 inspection. We all have to fill out I-9 forms when we're employed. And it basically tells the employer that we have, and the government, that we have authority to work. And obviously, if you're a US citizen, you have the authority to work, a green card holder, but others, it depends on your status, right? And you have to actually have permission. So what we've seen since the Trump administration has been in power, what we've seen is the use of I-9 inspections, basically to find immigrant workers. And so this provision requires employees, they do get notice. And as soon as they have, I believe they get notice. I don't know if there've been some surprise visits. You can enlighten me on that. But when employers are notified, they are required now to notify their own employers within 48 hours of receiving that notice of any pending I-9 inspection to verify employment eligibility, so that workers have some time to prepare. And go ahead, Gil. I know you have more to say about this.
I was just going to say the most concrete example, it was the Alston car wash, situation that we saw last year. Folks weren't notified that was going to happen, and therefore no one's carrying their documentation on them, right? That's just not something we simply do. And, they unlawfully detained people who may have had the proper documentation just not on them, and we want to make sure we're preventing those situations. But that's just as far as I know about this added protection here.
Next slide. Oops, there we go. And then we just kind of group the rest of them. We have a few things here. There is going to be a creation of an immigration commission with both government and other stakeholder members. This provision creates a 3-year standing immigration commission. And the idea here is that this isn't the last act on immigration bills and laws impacting and helping our immigrant communities, that this commission is required to continue to advise the legislature and the public about ongoing issues that need to be addressed. Then there's civil rights protections. This is a big one, actually. This was this is part of the Senate bill. It allows U.S. constitutional rights claims to be brought against federal officials, so civil claims, lawsuits, if they're so in other words, if anyone in Massachusetts, U.S. constitutional rights have been violated, they can bring a claim against the federal agent in court. Then there is a bail determination provision that allows courts to consider the existence of a final order of removal in bail determinations. It does not, it's not clear who brings up that existence of the final order of removal. If that's, I believe it's a prosecutor, whereas we know that some people, that sometimes defendants have asked to not be granted bail because of the danger of being picked up by ICE upon release. I don't know if there's more you want to say about that.
No.
Okay. And then finally, there's a new provision that was added. It was not in either the House or Senate bill. It's a so-called technical correction. And there's a new provision that allows the state auditor to audit immigration detention facilities and contracts and look for compliance with health and safety and other standards and practices. And this includes both the intergovernmental service agreements or detention agreements, like, for example, the detention agreement in Plymouth, and any private facility in Massachusetts that's leased or operated by ICE, private facility, that uses or impacts municipal or state services, property, infrastructure, or assistance, and that means the Burlington facility. So this is a very interesting provision, and we're really looking forward to hopefully seeing a state audit of that facility soon. Anything you'd like to add, Gil?
I think, we've been given more tools to add into our toolbox here, and some that we didn't have before. And so I think that's a win, and I hope that we get to use them. From a policy perspective, that is, of course.
Yeah. And again, we're hoping to bring in other folks to talk in more depth about some of the other provisions that we were not actively involved in working on. That is it for the formal presentation, and we'd love to hear your questions.